Habeas Corpus, which means you have the body. It is the most powerful legal tool we have to protect our right to liberty. The right under the Constitution of any person to apply urgently to the High Court to challenge the lawfulness of their detention. The remedy commands the detaining authority to produce the detained person in court, and if the lawfulness of the detention cannot be justified, the person walks free. Welcome to Series 2 of the Irish Courts podcast, where we continue to explore the impact the courts have had on Irish society. In this episode, we are looking at habeas corpus, a remedy that reaches deep into the roots of Irish history, from persecuted priests during the Reformation to the United Irishmen to Republican prisoners sentenced to death during the Irish Revolution. This ancient remedy has sparked constitutional crisis and remains to this day the most important remedy available to protect a citizen's right to liberty. Dr. Bláthna Ruane, Senior Counsel.
But there is a sense of urgency with habeas corpus, and it addresses the root of the problem. Get the body of the person into court, and now you justify why this person should be detained.
If you didn't have that or something like it, well, it'd be hard to say that you had a free society.
Mr. Justice Gerard Hogan, Judge of the Supreme Court.
The longer history of Ireland demonstrated that habeas corpus was an absolutely essential protection because it was such an important protection against government oppression that it would have been seen as something that absolutely was non-negotiable. 19th century Ireland had been a century of extraordinary coercion. Every time there was a build-up of tension and military action or minor rebellions or tensions at a local level, another coercion act would be introduced, and it would have been seen as one of the most important things to go into the Constitution.
Well, the reason why it's there is because of the experience of many of those who were involved in the drafting of the 1922 Constitution, of what had happened during the War of Independence. Individuals who would have been certainly executed by the British were saved by reference to habeas corpus, and I think they became convinced that it was vital that the right to apply for habeas corpus be set out in the Constitution and it be protected.
It is a hard-won right that is now enshrined in our Constitution under Article 40.4.2. A remedy with a history that stretches back centuries, born of long struggles for liberty. Associate Professor Kevin Costello.
I think we'll start with England because Irish law originates as an application of English common law. The sort of the origins of habeas corpus as a remedy against the state, against the executive, begins during the Elizabethan period. But 2 or 3 cases have emerged, and they've been discovered, actually, interestingly, just in the last couple of years. One case from 1665, this is Mitton's case, another case from 1668, and these were cases involving Catholic priests in Reformation England, where, of course, the practice of Catholicism was criminally suppressed. And these priests were hauled before a court called the Court of High Commission, which was a court intended to suppress Catholicism and Catholic practices and to impose what was called religious discipline. And both of these priests were imprisoned by the Court of High Commission. And remarkably, they took habeas corpus, and the court ordered their release on the basis that the Court of High Commission did not have the power to detain. They couldn't be detained given the commission given to the court. By any standards, this is remarkable. The law is being imposed against an autocratic monarch, and there are no consequences. The orders are observed. So that's how the process begins. We don't really have a sort of a satisfactory paper trail as to when the process begins to be used in Ireland. Irish law would normally follow English law, but we don't know when habeas corpus in Ireland was first used because of the tragic destruction of our court records in 1922.
The court records, part of the Public Records Office that was kept in the 4 courts, On June the 30th, 1922, at the start of the Irish Civil War, an explosion in the Four Courts destroyed 800 years of Irish history and records.
But there are alternative sources, and probably the first real sense that we have of habeas corpus being used against the state occurs just after the restoration of the Crown in 1664. And what happens here is a group of Dominican friars are picked up in Galway, and they threaten habeas corpus, seeking their release from an order by the Irish Privy Council, by the Irish Cabinet. And this causes panic amongst the Irish administration, who actually make sort of back-channel approaches to the Chief Justice, James Barry. And this is not the judiciary, I think, at its best. And the Chief Justice says that he will see what he can do to ensure that the Dominican friars, if they do go ahead with their habeas corpus application, were not to be released. And I suppose the next really leading case is Wolfe Tone's case. So Wolfe Tone was court-martialed in November 1798, found guilty of treason for aiding an invasion of Ireland by French forces, enemies of the Crown, and acting as an affiliate of enemies of the Crown. He appears in tribunal in a French uniform. He doesn't contest the charge. What he does plead for is a more lenient way, or less public and humiliating way, of carrying out the sentence of death, to which he's reconciled himself. That's refused him. And on Sunday, the 11th of November, he manages to get his hands on a penknife and he slits his throat. And he lingers. He's lingering. His father takes an application. Peter takes an application on behalf of Wolfe Tone. And this is an example of a principle which is unique in some ways to habeas corpus, which is that the application doesn't have to be taken by the prisoner himself. It can be taken on behalf of the prisoner by a third party. And this is particularly useful where, for example, a prisoner is being held incommunicado or often is just not well enough to take the application themselves. The application is presented on behalf of Peter Tone by John Philpott Curran, who is the radical barrister who acts for all of the United Irishmen during the 1790s. And Curran argues there is no basis for martial law because martial law is a response to the fact that the courts are not sitting. It fills the vacuum of the absence of... And here the courts are clearly sitting. Here's the Court of King's Bench and here's the Chief Justice, Lord Kilwarden. Of course the courts are. And an order is made to suspend the execution. And the military authorities refuse to observe the order. There is now a constitutional crisis. The judge repeats the order. And the constitutional crisis, tragically, is only averted by the fact that Wolfe Tone dies. Wolfe Tone eventually dies of the wound that was inflicted on him on Sunday, the 11th of November.
Obviously, the remedy of habeas corpus is an incredibly historic and important remedy. We didn't get it in Ireland for a long time, partly also because we didn't have judicial independence, even the basic independence until the 18th century. But through a series of cases that took place in early 1921, at the height of the War of Independence, key practitioners were involved, in particular Hugh Kennedy. Now, what happened first was there was a case, an infamous case. Sean Allen from Cork was denied an order of habeas corpus against a military court determination, and he was executed. His execution was at the end of February 1921. And then there were several other cases that came on shortly thereafter, and there were more executions at the end of April. Now, people like Hugh Kennedy, who was a radical nationalist lawyer, a very, very bright man, was appalled at this denial of habeas corpus. But he brought an application in the famous case of Egan and Macready.
Egan was being held under martial law in Limerick and was facing the death penalty for activities on behalf of the Republicans during the War of Independence. Court of King's Bench refused the application. They applied the principle that had been laid down in a case called John Allen's case, and they held, look, where there is a rebellion, then as a matter of necessity, because the ordinary courts can't function normally, the operation of the regulation of law and order is entrusted to the military, and the courts cannot review at least during the period of this crisis, they cannot review the legality or the propriety or the proportionality of what the military is doing. So in this case, Egan, for a relatively harmless offence, had been sentenced to death. And the court said that's not something that we can investigate, at the time at least. Egan then went from the Court of King's Bench to another division within the Four Courts, the Court of Chancery. And here the Master of the Rolls, O'Connor, took a more sympathetic view.
Egan was represented by Hugh Kennedy, who later became Attorney General and Chief Justice in the new Free State, and by John A. Costello, who later became Taoiseach. They went to the Chancery Division to Charles O'Connor. O'Connor granted habeas corpus.
Now, as you know, law has two kind of main sources. First of all, there's law that's generated by legislature, statutes. And then there's law generated by the courts. That's the second body. That's usually called common law. So the classical position is that because of the sovereignty of Parliament, it's legislation that prevails, where there's a conflict between the two. And here there was such a conflict. Egan was being held and had been sentenced to death by a military court at common law. The Master of the Rolls said, well, look, we've got two bodies of law in conflict here, and therefore the legislation, that is the Restoration of Order in Ireland Act, must prevail. And therefore the detention of Egan, because it was at common law and because it wasn't under the Restoration of Order in Ireland Act, was unlawful.
O'Connor ordered Egan's release, and Macready, who was the British general essentially in charge in Ireland, refused to comply with the order for habeas corpus initially. And that gave rise to an immediate constitutional crisis. Lord George, the British Prime Minister, ordered Macready to comply with the order.
That continuing to defy the order of O'Connor and continuing to detain illegally Egan might disrupt the truce which had been agreed on the 11th of July.
Egan was released. Now, the truce came within 4 days later, but Egan and Macready seared into the nationals' consciousness of the importance of habeas corpus, and in particular, the right to be able to go to any judge of the High Court, to select your judge, have any judge hear the case and so on, was all regarded as very, very important.
This case had an absolutely electrifying effect on young Irish nationalist lawyers, the young Irish nationalist lawyers who were then about to assume power and draft the new constitution. And it is as a result of Egan and Macready that habeas corpus finds itself as a constitutional right. I don't think it would have been a constitutional right if there hadn't been something as psychologically exhilarating as the experience. And you can imagine what it must have felt like for those lawyers, you know, feeling that they had actually got an order for contempt against the officer in command of the British forces in Ireland. And that is a classic example of what's sometimes called lawfare, where litigation becomes part of a political strategy. You're fighting your enemy, not just on the streets, but in the courts as well. So Egan and Macready, like Wolfe Tone's case, is an example of Irish nationalist lawfare. So it's really as a result of Egan and Macready and Wolfe Tone's case, and maybe even going back further to the Elizabethan cases, that we have this provision in the Irish Constitution.
The fraught circumstances of the Irish Civil War led to further dramatic and even tragic examples of habeas corpus cases, such as the case of Erskine Childers.
In September 1922, the Dáil did sit, and the Dáil made a series of orders and regulations, not expressed in a formal law because they didn't have lawmaking powers under the treaty until the Free State came into operation, and that only happened on the 6th of December 1922. But they nonetheless made a series of orders, the effect of which was that if you were found in possession of weapons or ammunition, that you could be sentenced to death by a military tribunal. And in middle of November 1922, Erskine Childers, who had been the secretary to the treaty delegation, but who had since taken the anti-treaty side and was their chief propagandist, was captured. He was found in possession of a small pistol, which apparently had been given to him for self-protection by Michael Collins. And anyway, he was tried before a military tribunal and sentenced to death. This was around the middle of November 1922. Childers Council applied to Sir Charles O'Connor, the very judge who had heard the Egan and Macready case under different circumstances in July 1921, and they applied to him for habeas corpus on behalf of Erskine Childers. And essentially their case was that his detention was unlawful because he couldn't have been detained for possession of ammunition and weapons because the Dáil didn't have power to make a law, and no law was in existence which prohibited this. He'd been sentenced to death on a Friday. They applied to Charles O'Connor sitting at home over the weekend, and he ultimately granted an initial order of habeas corpus, but which restrained the provisional government from executing Childers. So the case was returnable, came back into court at 2 o'clock on a Monday, I think it was the 23rd of November 1922, and the counsel for the government was Hugh Kennedy, who had appeared in Egan and Macready, but on this occasion he was appearing for the provisional government. He was their legal advisor, and he said they wanted to put in a further affidavit and they were looking for time. Childers Council said, of course, there's no objection to that, but Kennedy said, no, that's fine, but we can't give an undertaking. We won't give an undertaking that we won't execute Childers in the meantime. So ultimately the case had to go ahead. The case went ahead for 4 days in late November 1922. At the end of the hearing, O'Connor retired and wrote out his judgment. O'Connor came back at 8 o'clock that evening, delivered a judgment, it is said by candlelight, in which he rather bitterly rejected the application for habeas corpus, saying that there was a state of war and that in those circumstances habeas corpus couldn't operate. If there was a state of war, the answer has to be that it was the fact that people like Erskine Childers had helped to bring that state of war about. So O'Connor really refused to take this application by Childers and, if you like, angrily denounced him in the habeas corpus judgment which he delivered. As I say, it was delivered at night, and at that point there was an application made by Childers Council to continue the stay or the injunction on the death sentence which the military tribunal had ordered. O'Connor refused to do that. He felt he had no jurisdiction to interfere with the military tribunal. And the following day, it is said that as Childers' legal team assembled with a view to filing a notice of appeal, they had been told that their client had been executed overnight. There was a lot of bitterness, obviously, about what had happened to Childers, but the Free State Constitution, which came into force on the 6th of December 1922, did solemnly protect the right to apply for habeas corpus.
Habeas corpus is particularly important because it becomes a potential flashpoint for the adjudication on much broader tensions and difficulties in society. That's particularly important where you have a kind of revolutionary situation or militant dissidents. Very often they're arrested, they then apply to the courts. The focus then shifts to the courts and in turn shifts to the judges. Now the judges are applying the law of the land, but inextricably, as happened in Ireland at the time of independence, people began to look at the judicial system itself and at the judges themselves and formed views as to whether they were doing their jobs correctly, whether they were biased, and that became a major tension point for about 3 or 4 years around the time of independence.
Now, for the first part of 1922, you had two judicial systems in Ireland. You had, if you like, the old British system, which was limping along and continuing, and you had the Dáil courts, which had been set up in August 1920 by the Dáil as a kind of to challenge the authority of the British courts in Ireland, and they were also continuing to operate.
As a means of undermining English rule in Ireland, the radical nationalists set up their own system of rival courts known as the Dáil or revolutionary courts. It was a 4-tier structure, and these operated as an alternative legal system. They took away a lot of business from the Crown courts, and they were operating in parallel. They were suppressed by the British troops, who saw them as really a sort of an in-your-face setup against the British government. But they continued to operate, and the radical nationalists took a lot of pride in the Dáil courts. So coming up to the treaty, a lot of the radical nationalists expected that their Dáil courts would take over. Now, they were never as sophisticated as the Crown courts, but they commanded a fair bit of confidence, and they kept going under incredibly difficult circumstances because they were suppressed. They were hearing cases in barns, in county halls, in hotels, etc. But people were going to them, particularly at the lower levels of jurisdiction. So they were always there on the side, and they were deeply resented by the British government, and I would imagine also by the Crown courts. After the treaty was signed and the constitution was being drafted, there was a provision, or an arrangement reached in January that Crown courts were to continue rather than the Dáil courts, which it had been understood by a lot of radical nationalists would now take over the reins. But in fact, the British insisted that the Crown judges would continue on. So the judges are still doing their work. The Crown judges are still doing their work every day. The sense one gets from looking at their papers and the communications was that they really didn't get to grips with the seismic changes that were taking place in Irish society. It was like the tectonic plates were moving under them, and they didn't quite understand how everything had changed. The old, what we call the Crown judiciary now, were very differently constituted than the judiciary since independence. They were appointed by the British government. They were, for the most part, very associated with the British administration in Ireland. While they had an oath to be, perform their functions fairly, etc., they held office for life and they couldn't be removed. Notwithstanding all of that, they were very, very closely involved in assisting the British administration with the running of the country. Now, that manifested itself in the fact that they were privy councillors, many of them, and that meant that they would go to Dublin Castle to sign orders or proclamations. They would help to advise the Chief Secretary or the Lord Lieutenant when they were making key decisions. So they were really embedded right within the centre of the administration. Now, I suppose a lot of non-legal people wouldn't have necessarily realised that at the time, but importantly, in that era, the very senior radical nationalist lawyers who were involved in advising the government of the day, the provisional government, they realised that very clearly, and they resented the fact that there was this duality of roles. And Chief Justice Kennedy said in a private letter to Cosgrave, W.T. Cosgrave, who was President of the Executive Council, and private letters tend to be much more revealing, he talked about how they could go to Dublin Castle in the morning, sign a couple of orders, and then go down and sit on cases where the state was a party. And he said, we weren't even getting the basics of English justice, which was supposed to be wonderful justice. We weren't getting an independent judiciary. So there were a whole series of adjustments that took place. And I suppose the senior legal people who were involved in creating the changes, they knew very well what the key changes had to be in order to bring about proper independence. If you don't have an independent judiciary, an order for habeas corpus is far less likely to be given. And equally, if you have an independent judiciary, they need something like a habeas corpus to bring an issue to a head immediately. The outcome of the various habeas corpus cases, etc., was that when we got our constitution, first of all, there was no question of judges being members of the Oireachtas. So all that potential for engagement and rubbing shoulders on a frequent basis with politicians, all of that disappeared.
But the Free State Constitution, which came into force on the 6th of December 1922, did solemnly protect the right to apply for habeas corpus. That was more formally enunciated in the Constitution as originally drafted in 1937. What happened after that? In April 1941, the Second Amendment to the Constitution Act was passed. And what happened was this, was that the Department of Justice wanted to get rid of the right to apply to any judge of your choice. It wanted to be able to appeal the decision of the High Court to the Supreme Court. And there was opposition objections. John A. Costello reminded De Valera of the case of Egan and Macready, where he and Hugh Kennedy had selected their own judge. So De Valera relented to a degree, and there was a compromise. And the compromise was that there was a new version of Article 40, Section 4 of the Constitution put in. You could apply to each and every judge of the High Court for an initial order. But thereafter, there would be one single decision of the High Court, which in turn could be appealed to the Supreme Court. And those were the changes that were put into place. And that still has a resonance today.
This ancient remedy to protect the right to liberty is just as vital today. But how exactly does the process of habeas corpus work? Kevin Costello.
Okay, so the structure of habeas corpus is it's a process which is used where a person is unlawfully detained. It's a process that in which the High Court, and it's only the High Court, investigates the legality of that detention. And if the High Court finds that detention is not in accordance with the law, it may order the immediate release of the person who has been detained. So there are several elements in this structure. And the first is this idea of what is it to be detained. And there are two ways in which the law would understand a person to be detained. The first is where all exits are blocked. So where, for example, a person is held in a wing in a prison and the cell doors are closed, and that's classical detention. But the other way in which there can be detention is where if a person was to leave an open facility and would be apprehended if they were to leave that open facility, that counts as detention as well. And a good example of that occurred in 2021 during the quarantine regime for foreign travellers entering Ireland under the Health Amendment Act 2021. So foreign travellers would be taken to a hotel near the airport. They'd be accommodated in a room. The room door would be open. The hotel main doors would be open, but the army was stationed outside and guards were stationed outside. And if one of those persons who was quarantined attempted to leave, they would be apprehended. So it was acknowledged in court proceedings that that also constituted detention. So the process has a number of features which distinguish it from other forms of process. First of all, the application is initiated on what's called a complaint. And the Constitution says that what triggers an application for habeas corpus is a complaint. And it doesn't gloss or elaborate or detail or confine what a complaint is. You couldn't start a normal legal process by writing a letter, for example, to a judge, setting out a grievance. But you can under Article 40 or habeas corpus under the Constitution. The complaint doesn't require the kind of formalities in the form of paying fees or formal documentation that an ordinary application involves. Secondly, and really remarkably, the High Court must forthwith inquire. So normally legal proceedings are delayed. There's no obligation to immediately inquire into the cause of complaint. Article 44 is different. There must be an immediate inquiry by the judge to whom the complaint has been made into the legality of the detention. Another feature, just a third distinguishing feature, is that the application can be made to the High Court or any judge thereof. You have the right to submit your application to any judge of your choosing. So the next thing that the court does then is that it inquires into the legality of the detention. So the Constitution says that the High Court must order the release of the person unless the person is being detained in accordance with the law. And that then raises the question, what is it to be detained in accordance with the law? The first thing is that every detention follows usually two things. A finding like the person is dangerous for the purposes of, say, detention under mental health legislation, or the person has entered the country unlawfully for the purpose of detention under the immigration process. That's the finding element. And then there's procedure, like the detention must be authorised by an officer of the required rank or psychiatrist of the required qualification. And that then leads to the order. So a person determining whether there might be a case for under Article 40 will root around the legislation and see whether the required findings have been made and whether all the procedural steps have been taken.
Mental health and detentions under the Mental Health Act of 2001 have given rise to a series of Article 40 applications, of habeas corpus applications. And the reason why is that there are a lot of detailed safeguards that are in place before somebody can be arrested, not for committing a crime, but on the grounds that their mental status is said to be such that they present a danger to themselves or to other people. It's unlike, say, many ordinary arrests where a crime has been committed. Somebody has been assaulted or perhaps worse again, killed. But in terms of these arrests, they rest on essentially observations made by medical practitioners of the patient concerned. Sometimes people contend with success that they've been wrongfully arrested and detained under the Mental Treatment Act, and that's important that is established quickly. So it's very, very important safeguard for persons who are detained under the Mental Health Acts. On the other hand, the Mental Health Acts are very important pieces of legislation and, have to be made to work, and a balance struck between protecting the rights of the patients on the one hand and the interests of the family and the wider society on the other. But certainly habeas corpus is a key factor in many of these mental health cases.
Habeas corpus is the critical remedy for a person who is perhaps overwhelmed by a legal system, doesn't understand what is happening to them. They want to know why they've been arrested, why they've been detained, and habeas corpus is the remedy that allows that person to get quickly before a senior judge to have an adjudication as to whether they are being detained in accordance with law. It bypasses a lot of the factors that would otherwise delay getting before a judge. And as a result, it is critical. The judge can then form a view as to whether the state authorities are behaving as they should in accordance with law. And you can get a high-level determination of that, and you can find yourself released very quickly. Literally, you could leave court on the same day, a free person, or you could find yourself going back to detention to await further legal process. So it is a really vital remedy in any democratic system that's based on the rule of law.
Well, it enforces standards. We're not living in a period of crisis like we did in the 1920s or the 1790s or the 1880s. But it enforces standards of legality, particularly in the administration of the immigration process and the mental health process.
You sometimes see Department of Foreign Affairs guidance about other countries. You see on the website you're advised not to travel to country X or Y. And often one of the reasons given is that the risk of arbitrary detention is high. that means not just simply that you might be refused entry into the country, but if you're allowed into the country, that there's a risk that you will be detained on trumped-up charges and detained in prison and essentially coming before a judiciary that might not be independent. Your prospects could be fairly bleak in that situation. And that, in a sense, is enough to show how important habeas corpus is. Because if you didn't have it, a key safeguard in a free and democratic society would be undermined. And one of those safeguards is if you claim to be in illegal detention, that your case would be looked at carefully and scrutinised quickly by an independent judiciary who are committed to the rule of law.
Habeas corpus ensures that commitment to protect our right to liberty. An ancient remedy enshrined in the Constitution by revolutionary lawyers who fought to secure it. Habeas corpus, you have the body, remains the most important legal safeguard for the right to liberty. You have been listening to the Irish Courts Podcast, a curious broadcast production in partnership with the Court Service and the Judiciary. Our thanks to our contributors, Dr. Bláthna Ruane, Senior Counsel, Mr. Justice Gerard Hogan, and Associate Professor Kevin Costello.